Susan McGrath. I'm Director of the Center for Refugee Studies, and on behalf of everyone at CRS, I'm very pleased to welcome you all here. This is our second annual Howard Adelman Lecture, and very pleased to have such broad representation from academics and the NGO sector. I think we even have a token public servant here. So we and also very pleased to have such representation from the advocacy sector too. And I'd be remiss if not recognizing, I think, the elder of the sector, Fred Franklin, is with us tonight.
Of course, most of you will know that Howard Adelman was the founding director of the Center for Refugee Studies, formally organized in 1988. Sort of off to a very aggressive start. The highlights I hear of the 90s and all the work that he's done. He's probably the most prolific writer in the field of not just migration, forced migration issues, refugee, but certainly across health issues. His is a broad menu of things that he attacks, and everything is done with great detail and enthusiasm, and so prolific. 3 books in the last year, I think, Howard. So we're very fortunate, and this part of this lecture is to recognize his contribution not only to the center, and to York University, but also to the whole field of forced migration. And I also want to recognize a couple other people here who have done lots of contributions to the center. Michael Creel, who's been involved with the center for many years, and some of our founding people who worked with Howard. Winona Giles is here, Nergis Chenefe, Sherry Aiken, who's done our journal for years. So we're very fortunate to have, I won't say all of our elders, but certainly those who have made big contributions to the center. So we're very fortunate tonight to have Barbara Jackman who's going to be speaking to us and around the coming anniversary of the Singh decision. But first of all, I want to introduce David Dewitt, who's the Vice President Research and Innovation, Associate Vice President, and at York University, and bring greetings. So thank you.
I thought for a moment there that Susan had just given me a promotion. It's really a wonderful pleasure to have this opportunity to represent my colleagues at York University on this very important occasion. First of all, as an important occasion, if you haven't seen it, if you don't recognize her, you'll have to come closer. This is the York University Special Research Edition for this year of our magazine. And for those of you who can't see it, it's titled The People Crisis, and it has our own Susan McGrath on the cover, representing herself and her colleagues and her students from the Center for Refugee Studies, York University. This is an evening that really, truly celebrates excellence. It celebrates everything that a university, and in particular a public university, should be about. It acknowledges excellence in the whole notion of what scholarship is. Research, the creation of new knowledge, teaching, the dissemination and sharing of that knowledge, and outreach. Outreach to the communities, outreach in terms of partnerships, and outreach in the sense of trying to have an impact on people's lives. It's an important part of what makes Canada what it is. Foundation of a liberal democratic society is a first-rate, accessible system of education, and within that, opportunities for students and faculty and visitors to really excel. It is an evening to celebrate excellence because of Howard Adelman's path-breaking work in terms of refugee studies and his leadership work with colleagues in terms of creating the Center for Refugee Studies that's acknowledged by the lecture series. It's a celebration of excellence in terms of the work that the Center for Refugee Studies now undertakes, the work that Susan and her colleagues have done not only at the Center, but in founding the new program and Association for the Study of Forced Migration. It's a center of excellence. It's a celebration of excellence in terms of the quality of students that are attracted to York University to do work in this field. We're best known perhaps for our graduate students and our postdoctoral students, but for those of you who don't know, there is an active effort to recruit and support outstanding undergraduates through the certificate program. It's a celebration of excellence because of who we're honoring this evening. Someone who has a distinguished record in making a difference in an area which is central to the mandate of the Center for Refugee Studies and the original intent of the Excellence Award from CETA that founded the early years of the Center for Refugee Studies. So for all those reasons, it's really a privilege for me to have the opportunity on behalf of my colleagues at York University to acknowledge the Center for Refugee Studies, all of those who've been involved with it, and hopefully who will continue to be involved with it, and to now invite Howard to introduce our guest speaker.
Well, of course, it's a great honor to have someone giving a lecture in your name who's Barbara Jackman's stature. And you have to know...
Howard, use the mic.
Oh, it's going to raise it. Can you hear now? Yeah. I just said it's quite an honor to have a lectureship named after your honor where Barbara is giving the lecture. Barbara graduated from law school, and within 5 years, she's in the Supreme Court winning one of the most important cases I'd say in the last 25 years. It's an outstanding case because it makes a radical difference about the defining of the rights of people who aren't yet citizens, that they have rights and similar rights to Canadians, and it makes a difference in how Canada treats people and about the whole human rights regime in the world. It sets an enormous precedent. And Barbara, as a young person, does that and accomplishes that. And the reason she does it is because she's a gutsy woman. And she's brainy. She has brains and guts and determination. And if you knew her then, you saw it all in everything she did. She just went after something with just determination to get it done. And so winning this case was very important in Canada, very important for everybody, every refugee, and very important, I think, in showing what a Canadian, a single Canadian, a young Canadian could do in Canada to make a difference. She, of course, has won other laurels and has gone on. I was doing a lot of research on the detention cases. These are the security certificate cases, because I was not so much that I was involved in security cases at all, but I was interested in the legal concept of balance, and I published on it. And so as you go through the cases, Barbara's name keeps coming up, because here's one of the most important persons involved in those cases. Barbara was recently awarded a couple years ago with a Doctor of Laws, an honorary Doctor of Laws, and so I'm going to introduce Dr. Barbara Jackman to speak to you.
Well, I have to say I'm honored to speak at the Howard Adelman Lecture Series because I've known Howard for many years, and I have to say when I was a student, Howard was one of the people that we looked up to because of the incredible work that he did in mounting support across Canada for the Vietnamese boat people. And I think that was the precursor to a real viable refugee system in Canada, was because of Howard's efforts. So thank you, Howard. I want to make a couple of preliminary comments to my speech. Sorry. One is that, first of all, I'm not an academic. I'm an advocate. I'm not objective. I'm a defense counsel. So I found it very difficult in terms of trying to figure out the impact of Singh in a way that was not so imbalanced and negative that it would leave you all going home crying. So I will try to be a little bit more balanced than I usually am. The second thing I wanted to do was just sort of fill you in a bit on the background to Singh. Singh was my first time arguing an appeal in the Supreme Court of Canada, and the reason that we got involved was I was acting for one of the people on the Grange Commission, the investigation into the deaths of children at Sick Kids Hospital, and Ian Scott sat in front of us, and Ian knew that I did refugee immigration work, so he was acting for the Singhs in the Supreme Court. The Supreme Court had appointed him, so he passed his factum to us and asked me to review it, and I told him that I thought he was making the wrong arguments. He was arguing that what we call the Ellis-Island distinction. He was arguing that if you were in Canada, you were entitled to protection under Section 7 of the Charter, that you had a right to life, liberty, and security of the person, but that if you hadn't actually come into Canada, if you were still at the border, you wouldn't have that right. That's how the Americans, roughly that's the American distinction. The problem is that 6 of the Singhs were port of entry cases. They had never actually come into Canada. They'd been in Canada for 6 or 7 years, but they hadn't actually come into Canada. So I told him it was the wrong argument. He shouldn't make that argument. He wouldn't change his arguments. So I went to the churches and said, I think you've got to do something. And I went to Mendel Green because Mendel could always get money. And Mendel was acting for the Sikhs, and they didn't know what to do because they had a lot of refugee claimants who were all losing their cases. So Mendel and I teamed up and got both the Sikh Federation and the churches involved, and we did this factum. And those of you that have never worked without computers would laugh. We did the application for leave to intervene over the Easter weekend on a typewriter, and none of us were good typists. So what we would do is if we had a good paragraph, but we figured we had to change the page, we'd cut the paragraph out, Xerox it on another page, and then start typing. And you wouldn't believe how many pages we cut. In fact, I probably still have the cut pages somewhere. So we finally finished the factum. We got in front of the Supreme Court on a leave application on the Friday and had to be in court the next Tuesday, I think it was, to argue. So because we had no money, we drove to Ottawa to argue the leave application, drove back, then came back to Toronto for the weekend, prepared, and then drove to Ottawa and stayed with friends. It was much different than the way we do it now. And I was the one that got to argue because I'd done most of the work. So I insisted that I should have the right to argue the case. So we started for the interveners at the end of the first day of argument. Back then they didn't control the hours so much, like you didn't have a fixed time. I was so nervous. For any of you who are going to be litigators, like if you're students, you haven't really argued, don't worry, like you'll get over it eventually. I had butterflies in my stomach. I dropped my book, lost my place, and the Chief Justice adjourned to the next day because I couldn't find my place. I was so embarrassed. So I got control overnight and was able to argue it the next day. And successfully. In the end, it worked out well, and the court accepted the arguments that were put forward by the churches and the Sikhs, that everyone meant everyone who was in Canada. So in that sense, it was an important victory. The court decided that life, liberty, and security of person, when the Charter said everyone has the right to life, liberty, and security of the person, everyone meant every human being in Canada, whether or not they were lawfully admitted or not lawfully admitted. If they were on our soil, they had the protection of the Charter. The judgment was formative. It sent a message, I think, early in the life of the Charter of Rights and Freedoms, which was then only 3 years old, that it was an inclusive document, that it embraced the strangers in our midst and ensured that they too were entitled to fair treatment in the determination of their rights. When you think about it, where we're at in Canada 25 years later, I think in a legal sense we are far advanced, and in a structural sense we are far advanced from where we were 25 years ago. But having said that, there are a lot of serious problems that still continue to exist. If you look at the Singh decision, since that time, while the Supreme Court has always qualified its judgments in non-citizen cases with the recognition that non-citizens have no right to enter or remain in Canada, and that must be the starting point for an analysis of any rights of non-citizens. The court has still maintained the principles that it established in the Singh case in a number of important decisions. In the Suresh case in 2002, the Supreme Court recognized as a general principle of law that Canada could not deport refugees and others in need of safe haven to face torture in another country. Canada, in that case, was trying to deport Mr. Suresh, a leader in the Tamil community, and alleged to be a leader of the LTT, the Tamil Tigers, then involved in an armed conflict in Sri Lanka, back to Sri Lanka where he would be detained. And the human rights reports indicated that people who were detained, particularly Tamils, not just Tamils, but particularly Tamils, were routinely tortured. So Suresh faced torture. Supreme Court said you can't do that. They did say that there may be exceptional reasons or exceptional circumstances where Canada could deport back to torture. The court has never decided that issue. It's still an issue that has to come up. It's one of the key issues, I think, that the Supreme Court's going to have to face someday, is when would exceptional circumstances exist. But I have to say, since Suresh, every case I've been involved in where it's been security, and not just security like your run-of-the-mill Tamil gang case or something like that, the government has found exceptional circumstances exist to remove someone to torture. Since the Suresh decision, and this is why I say there's problems, since the Suresh decision, although the court upheld the principle, the government, in order to get around it, decides no one's at risk of torture, and in any event, there are always exceptional reasons to send them back to torture. My end result will be that it's important to have the case law, it's important to keep using the case law, but the case law doesn't mean that you get where you want to go. It's still a constant, ongoing struggle, and you can see that from the cases. The other two important decisions, I think, that build on the Singh principles are the two Charkawi cases. In 2007, the Supreme Court of Canada recognized that even refugees accused of having some links to terrorism were entitled to a fair process. There were three cases. One of them was mine before the Supreme Court of Canada on the security certificates, where the evidence against the person was led in secret hearings. And under the security certificate regime, this was one of the one of the most difficult problems with the legislation, was that as soon as the certificate was imposed, the person was put in jail, and they didn't have a bail review. Sometimes the bail reviews, in fact, we did an average in terms of when they were entitled to a bail review was 120 days after the hearings completed and they weren't deported from Canada. That was 2.5 years on average from the time they were detained. This is Canada, putting people in jail without a review of the need to detain. So those were the issues that went before the Supreme Court. And what the Supreme Court said is that the overarching principle of fundamental justice that applies is that before a state can detain a person for a significant period of time, it must accord a fair judicial process. The court concluded that a fair process had to be the right to a hearing before an independent and impartial decision maker, that it had to be made on the facts and the law, and that it involved knowing the case against you and the right to answer that case. Those were the basic principles. In Singh, 25 years earlier, the Supreme Court had recognized the right to an oral hearing, the right to a fair hearing. So this is a reaffirmation, a further articulation of the rights that were first recognized in the case of non-citizens by the Supreme Court in Singh. The court decided that in national security cases, which these ones were, that even if you couldn't disclose the evidence, there had to be a way of ensuring that the interests of the person were protected in the secret hearing. So the court said that there had to be some kind of a special advocate process where there would be a lawyer in the secret hearing that advanced the interests of the person. And again, good decision. What do we get as a result? We get a better system. We have the special advocates, but our government chose the most restrictive of the special advocate systems. As soon as a special advocate goes into the closed hearing and sees the secret evidence, they can only talk to you with leave of the court. The leave of the court is on matters such, so far we've gotten orders saying that we can talk to the special advocates about scheduling. And in fact, we can talk, we actually had orders in February. One order was we could talk to the special advocates till February 6th, and then another order extending it till February 12th. That's how the system's presently working. So it's still better. Like, we're actually seeing things that the special advocates have convinced the judge do not need to be kept secret any longer, things that we should have seen 10 years ago. These cases have been going on a long time. So it's an improvement, but it's not perfect. Like, you just end up going from one level to the next in terms of sort of what's the next struggle. With respect to the detention issue, the Supreme Court, and no credit to them, they should have decided it years ago. They were asked to decide in 1992. It took them till 2008 to decide that review without, that the detention without a bail review to determine the need to detain was wrong, that you had to have a bail review, and thereafter, if the person's detention was maintained, you had to continue to have detention reviews to determine if the person needed to stay in jail. That law, frankly, was scandalous. I mean, who ever heard of a country except dictatorships, putting people in jail without bail, without an opportunity to go before a judge to have them decide if you should be released? So the Supreme Court did say you can't do it. It just took them like 12 years or so to say it. The next case that was important, and also in the context of fair hearings for non-citizens, is the second Charkawi decision, which came down in June of 2008. Even though the Canadian Security Intelligence Service, which does investigations of non-citizens for landing, everybody has to go through a background check, and if they have concerns, they may decide a person's inadmissible for having had links to terrorism or something like that. They're the ones responsible for these security certificates being imposed. The practice that CSIS had, although they were told year in and year out by the Security Intelligence Review Committee and others that they should be keeping their records because that's the only fair way to ensure a person has a fair hearing, they destroyed their records until the Supreme Court told them they can't do it anymore. That if they're going to have, an investigation, they have to maintain their records and give the person a fair shot at being able to challenge the evidence against them. They would do things like interview the person, not tape it, but make notes at least, and then destroy the notes, having done a report in which they editorialized about the interview. So they put in things like the person didn't acknowledge that he knew Mr. X, but later at the end of the interview reluctantly admitted that he did. Well, you find out from your client that Mr. X's name was said the wrong way and that he admitted at the end of the interview because he was shown a picture. Like, that's not a reluctant admission. It's an acknowledgement that finally you realize who he's talking about. But they twist the report. So the Supreme Court said, you got to keep the notes. And the Security Intelligence Review Committee has told them they should be taping. That's the safest way to ensure that their rights and that their credibility and the person's rights are protected. The Supreme Court also said, and I think this is significant as well, that the security service had to disclose not just the evidence it was using against the person, but exculpatory evidence. That in order to have a fair hearing, if you had evidence that helped the person, you had to disclose it if it's in your possession. And that's important because, for instance, CSIS goes around interviewing people in the community. Maybe two people say, well, I think the person might have been involved. I heard he was involved from so-and-so. But then 10 people say the opposite. Oh, no, I've never heard that he was involved. Well, unless you get the evidence from the 10, you don't get a fair impression of the investigation. And CSIS was never disclosing the evidence of the 10. They were destroying it. So now they can't destroy it, and they have to disclose it. So it actually is an improvement. But, again, where are we at as a result of Charkawi? In the security certificate cases, which I'm involved in, we will get disclosure. They put the new certificates on them because of the Supreme Court's judgment in February of 2008. We are now in November of 2009, coming up to February 2010 in a few months, and we still don't have disclosure. We have not had the hearings get on. In my two cases, Mr. Majoob's case started first in June 2000, Mr. Jabala's in April 1999, and again in August 2001. They have not had a final fair hearing on the merits of the case against them. So they will get the disclosure that they're entitled to eventually, maybe before they retire. Actually, they're not allowed to work, so they can't really retire. But what's the effect of Charkawi 2? The government lawyers are taking the position in all the other hearings where they're presenting secret evidence or they're making security allegations against people and CSIS has done an investigation that they have no duty to disclose. That Charkawi only applies to these security certificate proceedings, not to deportation proceedings in the normal course, which will have the same result as the federal court proceedings, that the Supreme Court really didn't mean that fairness was required in all proceedings where you're trying to deport someone to torture. So there's a lot to deal with in terms of trying to have the principles applied in a regular place, in the normal way. I think that if you look at the decisions, there are a lot of problems around carrying them out in a fair way with governments, and I can't just say it's a single government, maybe bureaucrats, reluctant to apply them. So in a sense, when we won the Singh case, I think I even realized then, although I was much more hopeful and less cynical about the justice system, I think I realized even then that it would still be an uphill battle, that we won the right to an oral hearing, but it was going to depend on how they implemented the decision. And I think that gives rise to other considerations around where we're at today. I think that if you look at it overall, structurally, we are miles ahead of where we were when I first started practicing law. When I started and because of the Singh decision, when I started practicing refugee law, my clients would have an interview before a senior enforcement officer. They would make a transcript, send it up to a faceless committee in Ottawa who would make a decision and advise the minister whether or not to recognize my client as a refugee. Now we have full oral hearings in front of an independent and impartial decision maker. That's a huge advance, notwithstanding the problems in the system. The problems with it is that the decision makers are key to fair decision making. And if the government is going to act in bad faith and appoint people who are not qualified to make the decisions, or whose bent is anti-immigrant or anti-refugee, you can destroy what looks on paper to be a good system. I think it's no surprise that in there was an article in the paper a while ago that the refugee acceptance rate dropped 56% in the last year. So that doesn't speak well of an effective and robust and viable system if it can drop that quickly because of a changing government. Secondly, I think one of the key problems with the current system, even though we have oral hearings, is there's no effective review. They passed a law saying that we would have a refugee appeal division. We never got it. Instead, we have leave in the federal court. And in the federal court, the leave, you have to ask for permission to argue a case to review a refugee decision or any immigration decision in front of a federal court judge. They give leave in 10 to 15% of the cases. And I can't speak for the judges now, but I remember one judge telling me a number of years ago that he said, what's your office acceptance rate on these leave applications? I said, it's probably about 35, 40%. And he said, well, that's really good because I keep my leaves down to 10%. Like, that's a form of docket control. That's not a determination of whether or not there's a serious issue being raised that the court should look at. I can understand that the judges don't want to get overloaded with cases, but if there are serious issues being raised, they should hear the case. So it's not an effective form of review. You can have a case which raises an issue that's unresolved, and you'll get leave in 3 cases raising the same issue and not the 4th. So what happens to the 4th person? He just loses out because the judge didn't want to give leave, even though the other cases will proceed on exactly the same issue, and ultimately they may win in court, and the person who didn't get leave is lost. When you do get leave, the acceptance rate's about 50%, roughly. The third issue with an effective refugee system, aside from those 2 issues, is the lack of resources. I mean, for a long time, they weren't appointing board members under the current government. From what I understand, there's something like a 60,000 backlog of claims. When we succeeded on the Singh case, I don't know if some of you may remember, but there was a backlog program because there was a backlog of cases the government couldn't handle as a result of the Singh decision. They were cases that all had to be given an oral hearing after the Supreme Court said they were entitled to one. 23,000 cases That was the backlog in 1985. We now have 60,000 in the normal course. There's no backlog program or no amnesty for them. But if you don't put in enough resources, you're not going to have an effective system. People shouldn't have to wait a year and a half to get their refugee claims decided. One of the problems I find in terms of doing this work, and I was talking to Shari at the table about it, is the enormous human cost as a result of ineffective or unfair systems that we have in place. So you got to remember that some woman comes and makes a refugee claim. She may have had to leave her 2 little children behind. It takes a year and a half for her to get her refugee claim on, and then the landing process takes another year to a year and a half. I mean, how long is she separated from her kids? Like, it's really, really a terrible system when it doesn't work properly, and it's terrible in terms of the human cost on people. I don't think our government thinks enough about that. The other thing that I think as a result of the heightened awareness of the need to respect human rights and to protect people from harm, people from other countries, has been the increasing importance of other options under the immigration scheme. That's the humanitarian compassionate application, where immigration officers can look at the question of whether a person's at risk, maybe not in a refugee sense, but in a discrimination sense or something like that. It's a broader sense of harm that can be considered in the humanitarian and compassionate application. That has become a very important vehicle for people to prevent their removal to places where they would not have tolerable lives. And the other system that's in place is the pre-removal risk assessment system, risk assessment program, where if you lose your refugee case, theoretically, if you're on your way out the door, someone will take a last good look at whether or not you're at risk. That, I think the 2 programs are essential for 2 reasons. One, because people fall through the cracks. They have lousy lawyers representing them, or they don't even have lawyers. They have consultants who are not good. I mean, there are good consultants, but there's also ones that don't do effective jobs, or maybe they go unrepresented. They need to have a way of being able to put forward a solid case if they have one and weren't able to in the first instance. The humanitarian and compassionate and the pre-removal risk assessment program allows for that, to catch people who fell through the cracks. And the other thing is that there's changes in conditions. Like, you just have to think of the Tamil experience over the last year. Since the peace process in Sri Lanka was put in place in 2002, the acceptance rate for refugees from Sri Lanka went way, way, way down for Tamils from Sri Lanka, because they do this all the time. Everyone thinks, oh, well, now they're on their way to peace, they're going to be okay, they're not going to persecute Tamils. Well, it didn't work out that way. But there's always a lag time in terms of recognizing when the problems have started again and people are at risk. They still continue to refuse them until it's patently clear that they're killing them, and then they start to recognize them as refugees again. So for Tamils that were caught or were refused before the war really started again and people were put in camps and started disappearing and started being killed, the PRA and the agency are one way of protecting them. You can't reopen the refugee case. So if you can't reopen it, somebody's got to look at the issues of changed country conditions if they've worsened. So those mechanisms are important for that, and they do work. They don't work well. I mean, it's very difficult to win them. I mean, the acceptance rate on the PRA is really, really low, but there's the odd case where someone's life is saved because of it. Again, there is a problem in terms of resourcing. So once the humanitarian case became more important, the Baker decision in the Supreme Court of Canada recognized that immigration officers had to look at the best interests of children when they're deporting parents or even deporting children. And so that was in the context of a humanitarian application. So as that became a more important process, the government put less money in it. So it used to be that you waited 6 months for a humanitarian decision to be made, then you waited a year. I remember years ago there was this official, Phil Peary, very nice guy, but he kept doing charts on when they were going to make their decisions. They never met their chart times. But he kept making charts anyways. It was the kind of thing you could do a movie about, chart maker. But in any event, it's now 5 years to get your humanitarian decision made in some cases. People are waiting 4 or 5 years, some longer than 5 years. they don't have a right to remain in Canada while they're waiting for a decision. So a lot of the work we do nowadays is trying to stop deportations until the humanitarian application is decided. What kind of effective right do you have to have your children's interests looked at if you're deported before they're looked at them, before they look at their interests? The government just doesn't put the resources in, they gut the program. So that's how they get around Baker and the requirement to look at children's interests. You just deport them before you have to look at them on the agency application. So there, like I said, there's problems. With the PRA, there's problems because it's not the kind of system where you can just put in evidence that should have been put in before. You have to justify why you couldn't have put it in before, and it may just be that you had lousy counsel. And to establish your counsel was not good counsel is a very high test. I think that the biggest area where it has gotten worse, while at the same time looking better, is in terms of the security threats. When I first started practicing, this was pre-Singh, pre-fairness case law, I remember this Chilean friend of mine actually was called into immigration, so I went with him. And the officer said that he had a problem, he wasn't going to be landed, he was a refugee. And I said, so why? And he said, I can't tell you. And I said, well, can you tell me the section of the act that's being applied against him? No, I can't, for reasons of national security. We have come a long, long way since then. Now they'll tell you the section of the act and you actually get some evidence. You have a hearing. Since 1984, there have been hearings in front of the Security Intelligence Review Committee and now the Federal Court and the Immigration Division to determine if a person is a security threat and admissible on security grounds. But while we have the form of fairness, it's the laws that are unfair. So in 1992, the government passed a law that said anybody who's a member of a terrorist organization is inadmissible to Canada. Anybody who's a member of a criminal organization. Now, those sound serious, but when you look at the way they're applied, member of organized crime, you think the mafia and the triads. That's a serious problem and one that's organizations that are dedicated to crime, not your Tamil street gang or your neighborhood gang of teenagers who need to grow up and should be given a second chance if they can show that they're on the right track. They don't even get to have someone look at the humanitarian elements of their cases because they're caught by this organized crime provision. They don't get the appeals. They don't get anything. It's being applied too broadly. The member in a terrorist organization, you know, my case, Nawal Haji Khalil, her case has been in the press, it's in the courts. Reporter wrote for a PLO magazine. All she ever did was write articles about what was going on, not inciting anybody to violence or anything. And for her, living as a stateless person in Lebanon when she wasn't supposed to be there, that was a good job, being able to write for the PLO magazine. She did nothing to anybody, but she's a terrorist because she wrote for the PLO magazine. That's too broad. That's too broad of a brush. And so it doesn't matter that you have a fair hearing. It's that the substance of what the hearing's about, you're not going to win. You're going to lose all the time because you were a member, effectively, in some way connected to the organization that they have a concern with. It's not that the terrorist organization is, like in refugee law, an organization with a single brutal purpose. It can be something like the Liberation Tigers of Tamil Eelam, which ran the court system and ran the civil administration in the north of Sri Lanka. So if you worked as a parking ticket operator, you're caught by the terrorism provisions. The PLO ran hospitals and clinics, the different organizations within the PLO. You're a doctor in one of the hospitals, you're caught by the provision. So fairness, fair hearing isn't the only issue in terms of governments around how to, in terms of fairness in a substantive sense. We haven't reached the fairness in a substantive sense, only in a due process sense. The other, I think, big issue in terms of substance is the return to torture issue or the return to persecution. And I just want to say something about how that's happened, because if you're found to be a member of a terrorist organization, there are two ways around it. First of all, if you are at risk of torture, you can't be removed. And secondly, if you're innocent or you haven't done anything wrong, you can get an exemption from the terrorist bar. So you were a member, but you didn't really do anything, the minister can say it's not against our national interest to let you become a permanent resident. We found out through examining officers that, for example, Minister Robillard, who was the Minister of Immigration, never signed off an exemption because politically she didn't want to be seen to be signing off on exemptions, exempting someone who was alleged to be a terrorist. She thought it would hurt her political career. So the exemption was effectively gutted through the whole time that she was minister. The current government, as far as I know, they have signed off on one positive exemption request. That was a holdover from the Liberals. They have not said yes to anybody else, and what they are doing is sitting on the rest of them. That exemption is not an effective exemption. It's a political exemption that doesn't work. How do you get at it? With difficulty. Some cases have been won on the process, whether the person's being treated fairly, but not on the substance of how the government makes decisions on those proceedings. With respect to the return to torture issue, protecting yourself against a return to torture, again, my experience since the Surish case has been not a single case where the government has used the security process have they ever found that a person's a torturer, or that the risk that they present to national security does not override the risk that they face of torture. I mean, does override the risk that they face of torture in their home country. So again, it's not an effective balancing process. The courts probably because courts are like that, don't want to make the ultimate decision. So we get to court, like in the security certificate cases, we've been to court in some of the cases 3 times on the return to torture issue. Each time the court has allowed the decision and sent the matter back to be looked at again by the minister's delegate, only to have it turned down again. We win again, it's turned down again, we go back to court, we win again. And now we're sitting waiting for these new proceedings to complete, and then they'll look at it again, they'll turn it down again, and we'll go back to court again. It's like, how many years can you go through doing this in what is effectively an illusory system that doesn't work? And the stakes are very high for some of these people. They're going back to countries where they would be tortured. Those issues have not been decided by the court yet. And the last thing I want to say about sort of the people who are caught up, who are in need of protection but caught up in the security scheme, where I think that, again, the law gives the appearance of a fair process but in substance doesn't, is what I call the control orders cases. The persons who, and it's not just security certificate cases, it's happening at the immigration division as well. Non-citizens, somebody has to tell me if I'm going over my time. Okay, because I don't have a clock up here. But I'm getting close to the end. With the security certificate cases, and now also other non-citizens where there's a concern about security or criminality, they know ultimately that they can't remove them, some of them. That's the case with us, with Mr. Majoub and Mr. Jabala, and I think the other security certificate detainees. We go through this cyclical process of reviewing decisions in court to remove them where they win. They never get a final answer. In Mr. Jabala's case, the court did say there weren't exceptional circumstances in one of his cases to return him, but now it's back on the drawing board again for them to look at the issue again. In the meantime, the federal court has imposed conditions on them on release, or the immigration division in a couple of cases that have imposed conditions on release, which are very stringent conditions, and they're meant to address the security concerns. I feel terrible because we participated in assisting the court in drafting these conditions when the men were detained, and we wanted to get them out. They had wives and children. They'd been detained. Mr. Jabal had been detained 6 years. I think Mr. Majoub 7 years. I think Hassan Almri, by the time he got out in 2009, was detained in 2001, so 8 years. So we're busy trying to craft orders that will satisfy the court and the government so our clients can get out and be with their families. So they end up with orders, starting with a case that I wasn't involved in, they end up with orders which puts them under 24-hour supervision by their family members. The wives and the older kids are their supervisors. They can't be alone at home. They can't be alone outside the house. They have to wear GPS. If they want to go outside the house, they have to ask for permission from the CBSA. CBSA has to prove the places they go to. And then on top of and they say no if they don't like the place or if they think it's too busy or whatever. And then on top of that, CBSA was having surveillance, eyes on surveillance, eyes on surveillance on them every time they went out. So you went to Chuck E. Cheese, they were sitting beside you at the table, the next table, the officers. You went to Wonderland, they were on the ride with your kids. It was just like too much. I didn't realize these are cases that are going to go on forever. I never realized, and I think anybody who's sort of a sociologist or a psychologist might want to study some of these, the effects of these cases, because I've never seen it before. It's a complete degeneration of the integrity of that family and the family members, and the people harmed the most are the children. Like, you know, one of the Jabala children wanted to buy a present for his mom. He talked about this in court. Wanted to buy a present for his mom. The officer was beside him. He walked out the store and didn't buy the present. He didn't want the officer to know what he was going to buy his mother for her birthday. But to grow up as a child and have this going on around you all the time is really harmful. And I feel terrible that we help participate in it by trying to craft a way of getting their dads out of jail. We're destroying the children in the process. So now we've got psychiatric assessments. The Majub family broke up. He's back in jail. The family couldn't cope with it anymore. The Jabala family are still sort of coping. But we got this psych assessment, and the psychiatrist, child psychiatrist, and the psychotherapist or whatever that works with him, psychologist maybe, they basically said these children have been irreparably harmed and they will not recover from it because they have missed developmental markers that are normal for children. And they've missed them because of the conditions imposed on them that so restrict their lives. They can't have friends come over after school because how are they going to get the friends home? They can't go to the friend's house. How are they going to be picked up? You don't want your 9-year-old walking home, 20 blocks from a friend's house at night. But you can't go pick them up because you don't have an outing to be able to go pick them up. Your wife can't leave you to go pick them up because she can't leave you at home alone. They can't join clubs after school. It's just so restricted their lives. We're in court right now talking about arguing that's indefinite, that we can't see any end in sight. We can keep coming back every 6 months, and the court on this cascading to liberty kind of theory will maybe take away one little condition or make, instead of 2 outings a week for 4 hours, you get 3 outings for 5 hours. That doesn't work when you're destroying a family. So, although we go to court, we have the hearings, the judges can look at the issues. At the end of the day, are they better off? I have to hope that we are better off in the sense that we have hearings. We can go somewhere, we can go up to a higher court if we get leave. And if we can't someday on a real serious issue, we can always go to the Ontario court and try and argue there that we should have them hear our case. There are options. But I have to say I never in my early years of practice ever faced the emotional trauma that I see now as a result of the immigration system. I've never seen lives so destroyed as what we see now. It's this mean-spiritedness that sort of developed within the government. Maybe they're afraid of strangers or they're afraid we'll be overrun. But the reaction, and it started long before September 11th. September 11th just heightened it. But I don't know how you overcome it. I really don't. I think that going to court, I still am a strong believer that if we didn't have Singh, if we didn't have Surish, if we didn't have Charkawi, we'd be worse off. And that eventually, you just keep going back and knocking on the door of the court and trying to make them see that this is wrong, that eventually they'll see, and that someday, it will improve. But it's got to improve not just in a legal sense. The words written by the court are wonderful, but in practice, the governments have to carry them out, not try and obfuscate or obstruct them. So there's lots of work for those of us that are getting older and aren't going to be around practicing forever. There's lots of work for the rest of you coming up. Believe me, there's more than enough work for you to do in the future. Thank you.
Thank you, Barbara. And we're fortunate enough tonight actually to have two former IRB members here, Audrey Macklin and Peter Schauler, who have now become activist academics, along with people like Sherry. And Audrey Macklin from the Faculty of Law, University of Toronto, is just going to respond and thank Barbara.
I was asked to deliver our collective thank you to Barb for, well, not just for her talk, but for all the work that she has done over her career. And listening to Barb's talk and really feeling very moved by it, I guess I want to say something that will sound trite to begin with, which is a lot of us wouldn't be here tonight if not for Barb. Now, this seems a bit obvious. Yes, indeed, we wouldn't be at the Bright Pearl restaurant tonight if not for the fact that we're honoring Barb. But I mean, of course, something bigger than that. I mean, there are a lot of people in Canada today who would not be here today but for the representation that they received from Barb Jackman. There are a lot of people in Canada today who would not be here but for the fact that they got a hearing before a tribunal in their claim for refugee status that led to their acceptance and their permanent residence and ultimately their citizenship in Canada. And they also owe a thanks to Barb for the Singh decision and all that came after it. There are people like Peter and me who wouldn't be where we are if not for Barb and the Singh decision, because there wouldn't have been an IRB, a sort of sometimes independent tribunal, that we both sat on. I expect that there are a lot of refugee lawyers in this room who wouldn't be here today but for the inspiration of Barb's leadership and example. I expect that there are also a lot of non-lawyers who are advocates on behalf of refugees and non-citizens who would not be here today for the same reason. And finally, I'll say that as an academic, I would not be here in the same way that I am today but for Barb Jackman. And not only has she, of course, provided lots of fodder for me to teach my classes, lots of judgments that I can talk to my students about, not only in a course on migration law, but also in a course on administrative law, where increasingly cases involving immigrants and refugees have come to dominate the field in a way that labor law cases once did. But it's not only in that sense that I thank Barb. It's also as somebody who tries to think about the difficult questions posed by our relationship to those who are non-citizens, who are deemed then in law to be in some fundamental sense unequal because those of us who are citizens have an unqualified right to enter and remain, while those of us who are not citizens lack that entitlement. And the cases that Barb has argued and the theories that she has developed in those cases, the arguments that she has advanced, and the analysis that she has shared with us tonight, all challenge us, and certainly have challenged me as an academic, to think more deeply about how we recognize the common humanity of those who are not citizens, while acknowledging, conceding, if only because of the patent power of law, that they are, in the sense that I just described, fundamentally unequal. And I think the cases that Barb has described to us in her analysis show this constant struggle to expose and insist upon the equal humanity of those who our law, the existence of our laws of immigration, deem fundamentally unequal. And here I'm not trying to be polemical about it. That's just the nature of citizenship, and we all know how it works, and I'm not trying to kind of be overly rhetorical about it. I think what Barb has shared with us is the progress that has been made in large measure, no small measure, certainly, because of the very cases that Barb has taken on and argued and continues to argue about progress in relation to the equal humanity of the other, the non-citizen, in relation to what Barb has called procedural matters, right? The way in which they are entitled to a fair process in the determination of their entitlement to enter and remain in Canada. And one should not underestimate the force and importance of the equal entitlement to be heard and to be listened to. And in order to give full meaning to an entitlement to be heard and to be listened to, you have to know what's being said about you. And so that leads us into questions, for example, of disclosure and so on. And how do we, there's an important moment, I think, in making your stand as equally human, in that moment of saying, I'm entitled to know what you're saying about me, and I'm entitled to speak and to be heard. I think what Barb's also shared with us are the limits of that, when they bump up against that fundamental inequality that we know to be the case with people who aren't citizens. And so we are pushed and challenged to think about how can we recognize as equally human people who we can contemplate sort of with a straight face as better tortured than here. And how can we contemplate, and how can we take on board the equal humanity of people who we think better to warehouse them indefinitely than to make a decision about whether they do or do not constitute threats to us, and to then act upon the consequences of that decision. Those are really difficult and persistent questions. And I know I struggle with them as an academic. Barb struggles with them on the front line or in the courtroom. And I expect that all of us in the room, one way or another, struggle with that too. And again, I think we owe Barb an enormous debt of gratitude for shining a light on this struggle, helping us confront it, think through it, act through it, and keep going, even as she gives us a message that is both hopeful and dispiriting. Well, yeah. And really, for that and for so many other things, I thank Barb, and for all of us, I thank Barb. I don't know if we have time for questions, and there are so many that we could ask at this point. And maybe there aren't a lot of answers. But ask Barb. If not now, then another time. Thanks, everyone.
I think we'll close now. Really want to thank everyone for coming. Thank you, Audrey, for your very thoughtful comments following Barbara's speech. And we hope that you'll join us again next year. There'll be another annual lecture next year. And I think this seems to be that the Chinese restaurant was a theme, I think, in the 90s. And we're very pleased to have the turnout tonight. So perhaps we'll try it again next year and you'll join us again. So thank you so much, everyone, for coming.